Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Hello and welcome to LawPod. My name is Mark Hanna and the subject of today's podcast is on defamation law reform in Northern Ireland. In 2013, England and Wales adopted the Defamation Act, legislation that not only sought to codify a complex body of common law, but to address concerns about the chilling effect that defamation law was seen as having on free speech, and to strike a more adequate balance between right to reputation and freedom of expression. In 2016, having considered the implication for Scots law, the Scottish Law Commission proposed similar reform in Scotland. That bill, the Defamation and Malicious Publication Bill, was introduced in the Scottish Parliament in December 2019 and is now in its final amendment stage. The bill broadly reflects the reform adopted in England and Wales. That will leave Northern Ireland as the only part of the UK to yet reform defamation law. In 2013, when the Act was adopted in England and Wales, the then Minister for Finance declined to introduce a debate about reform to the Assembly. This raised concerns about free speech in Northern Ireland and also about the inevitable divergence between defamation law in Northern Ireland and that in England and Wales. Northern Ireland, with its relatively small population, had always relied upon the judgments of England and Wales Appeal Court to develop the law here. By going it alone, defamation law in Northern Ireland was effectively fossilised in its pre-2013 state. In response to these concerns, the Department of Finance asked Professor Andrew Scott of the London School of Economics to carry out a review of the desirability of reform of defamation law in Northern Ireland. A consultation report to that end was published in 2014, and after the Northern Ireland Law Commission closed in 2015, Professor Scott published a report which recognised the need for reform and recommended legislation that broadly reflected the 2013 Act. Those recommendations for reform have to date not been adopted here. In 2019, the Northern Ireland Department of Finance replied that there was no requirement under either international or domestic law to amend current defamation law in Northern Ireland, and argued that the existing common law framework here was enough to protect freedom of speech, and ultimately that this was a devolved matter within the competence of the Northern Ireland Assembly. Recently, however, a private member's bill has been introduced in the Assembly by Mike Nesbitt MLA, proposing the adoption of legislation that would closely reflect the Defamation Act of 2013 that was adopted in England and Wales. To correspond with the current opportunity for reform of the law in Northern Ireland and to discuss the various issues that defamation law reform presents today in Northern Ireland, we're joined by Andrew Scott, Professor at LSE and author of the aforementioned Scott Report, Daithí MacSithigh, Professor of Law and Innovation here at Queen's University Belfast, and Gavin Phillipson, Professor of Law at Bristol University. In the podcast, we discuss the legislative competence of the Assembly to reform the law in this area now, considering the implications for the reserved matter of data regulation. We talk about the wider implications of online communication, the public interest defence and whether Section 4 of the proposed legislation does a good job in protecting that, and the Section 1 requirement of serious harm and discursive remedies. Thanks for listening. I hope you find it useful.
Andrew Scott, I'd like to start with you, if I may. You published your report on defamation law in Northern Ireland in 2016. There have been significant changes in Northern Ireland since then and society more generally. Would you change anything in your advice to the Northern Ireland Assembly today, and if so, what?
Well, first of all, thanks very much for inviting me along today, Mark. It's very much a pleasure to be here with the other members of the panel and yourself. Since 2016, a number of things have changed. Certainly in terms of our experience, we now have 7 years of experience of the operation of English law of defamation under the Defamation Act of 2013. And in addition, we've seen an array of different analyses being conducted around the world where other jurisdictions which have similar defamation regimes, such as Scotland, Ontario, New South Wales, the Irish Republic, have considered changes to their own defamation laws and opened debates as to whether reform should happen and perhaps what should happen. Coming back to the report that I authored for the Department of Finance in 2016, you may recall that it actually proffered two alternative courses of action, two alternative paths forward. So one of them involved introducing a bill in the Assembly in Northern Ireland that would more or less emulate the 2013 Act. The other option was to introduce an alternative bill that would do more than that. So, taking the bill that would more or less emulate the 2013 Act, I think first of all, in light of what Mike Nesbitt has proposed at the minute, it's important to say that that first option in 2016 more or less emulated the 2013 Act. It wasn't exactly the same, whereas my understanding is that Mike's bill is effectively the same as that which was put into the statute book in England. And as we set out in the 2016 report, some of the changes that we thought were important, I think remain significant. So in contrast with Mike's bill, for instance, I would like to see some changes in the structure of the honest opinion defence. So one or two of these are, small, more or less semantic changes, but a relatively significant one concerns the basis upon which a person wanting to utilise the defence would be able to rest their opinion. And in essence here, the idea would be that a person could rely not only upon true or privileged facts, but also upon facts that he or she reasonably believed to be true at the moment whenever the opinion was published. We can talk about that a little bit more as we go on. Other changes relative to Mike's proposal or other differences in the 2016 proposal concerned sections 5 and sections 10, which, if you'll recall, relate to the position of internet intermediaries and other intermediaries. And in that proposal, we suggested that what we find in section 10, which is essentially the removal of potential liability for internet intermediaries unless conditions were fulfilled. The proposal would be that should actually be just a general exclusion from liability, which could, in certain circumstances, be addressed by identifying like a particularly recalcitrant online publisher as a publisher, or online intermediary as a publisher, but in the main would absolve those types of actors from potential defamation liability. If the plan is to closely follow the 2013 Act, I personally would like to see those sorts of proposals reintroduced into the bill, which makes the floor of the Assembly.
So you would like to see, the two things that stand out for you is the Section 3 honest opinion defence, and as I understand it, you want something a bit more expansive than what's proposed. Is that correct? And then secondly, also about what you've said about Section 5 and Section 10, those are provisions that relate to internet intermediaries. And what is the purpose in relation to the drop in Section 5 and having a more expansive definition of those in Section 10?
Well, the underpinning policy essentially concerns the potential harms which arise from making intermediaries of this type liable themselves for material that's published by other people. Okay, a material over which they have no personal input, perhaps no real knowledge themselves. Okay. So what then happens whenever such people are made liable is that rather than sort of engage in some sort of sophisticated contemplation of the rights and wrongs of the interests at stake, of the balancing of the reputational interest against the Article 10 interest, the right to free speech, they simply take material down, which generates a profound measure of what some people have called collateral censorship. It's a quick fix for the claimant, but it's not particularly helpful for people who might otherwise be well informed by the allegations that have been made on matters of potentially very significant public interest. Extending the Section 10 idea, and extending the exclusion from liability for such people wouldn't mean that there would be no recourse for the claimant. Ultimately, what it would effectively do would be to hand the question back into the hands of a judge. And a claimant would be able very quickly to go to court and seek an interim injunction requiring takedown of material that's been published, having given the gist of the argument regarding both sides of the balancing, requirement to the judge and have the judge determine, where the balance of justice lies. So normally in defamation proceedings, it's very difficult to get an injunction at an interim stage to provide for takedown. But in the scenario under a rule called the rule in Bonnard and Perryman, essentially what that rule says is that if a defendant comes to court and tells the judge that he or she plans to defend the action, then no interim award of an injunction will be made. The big problem in the area of online intermediaries is that usually the primary author or publisher is anonymous. Okay, so in these circumstances, that person would have to, effectively out themselves and come forward to the court to make an argument to the judge that the material should stay up, and only by doing so would they be able to frustrate the intentions of the claimant. Okay, so that effectively places the heat back onto the original publisher rather than the intermediary who has no particular stake in the matter.
So what you're suggesting then is, rather than enacting this provision 5, which is about the liability of website operators, just rely on that common law rule, and that in effect means that you fall back to this default position that this thing will sort itself out, and you don't have to get into the whole litigation of issues in order to get things removed from the internet, which people complain about, because most of the time people won't defend that. Is that the purpose there?
That's essentially the idea. And if we're thinking about Section 5 and emulating it, we need to have a look across the water and see what actually has happened in England. So regulations have been passed under Section 5, which would bring it into effect. But if essentially nobody is utilising those. So everyone who's engaged in this area, all of the internet intermediaries that might be called upon to take material down, are falling back upon pre-existing common law and statutory rules, in part as derived from EU law. And acting thereunder, which is effectively notice and takedown regimes, which aren't a tremendous advance on, which don't necessarily address the sorts of concerns about collateral censorship that concerned us in the first place, I think.
Well, I noticed it's interesting because Scotland, adopted a similar approach to your recommendation, and they don't have the Section 5 reference to the explicit reference to operators of websites. And there's an interesting dimension here, and I'm not sure it was ever your intention, but there's an interesting dimension here, I think, in light of the changes or the challenges rather that the bill in its current form has received in the Northern Ireland Assembly. And that's a question I had for you, Daithí, about one of the things that's come back in feedback to Mike Nesbitt is this idea that the Assembly doesn't have legislative competence for this kind of libel law reform any longer because it touches on reserved matters. Can you explain what that is exactly? What are these reserved matters, and how that might be an issue for a devolved Assembly that hopes to enact some reform of this area of defamation law?
Well, this is something where the common view across London and Belfast for many years now has been that defamation reform falls within the legislative competence of the Northern Ireland Assembly. There's been very little controversy about that at any stage, and so any argument now that there's an issue is much more likely to relate to one or more components of a bill rather than the bill as a whole. Now, in terms of what those components might be, the more general provisions found in Section 10 of the 2013 Act, in my mind, will be relatively easy to justify in terms of the powers of the Assembly. Although there are various differences between the devolution settlements, the Scottish Law Commission has done part of this work already because it's equivalent of the provisions in Section 10, which by and large have made their way into the bill that the Scottish Parliament has just completed its consideration of. There are a number of different bases in which they would fall within the competence of the Scottish Parliament, and certainly at least one of them would also be would have a parallel in Northern Ireland. Section 5 of the 2013 Act is probably a more difficult case. Because it wasn't part of the Scottish proposal, neither the Scottish Law Commission nor the Scottish Parliament gave any significant attention to legislative competence, and the provisions of Section 5 of the 2013 Act can be more explicitly categorized as regulating internet services, and internet services are one of those areas where, both in respect of Scotland and Northern Ireland, legislative competence is, in general terms, reserved to Westminster. And so the challenge for the Northern Ireland Assembly now will first be to work out what the problem is. And we would await information from the Speaker on that. Then the extent to which the bill, as proposed, could be amended with that in mind, or because, again, of the unique way in which the Northern Ireland Assembly operates, it is possible, which wasn't actually possible in the Scottish case, to get a particular form of Secretary of State consent in order to allow the bill to be considered.
Why was that not possible for Scotland to get the Secretary of State's consent? I mean, my understanding is that the issue here is that these are reserved matters for both the Scottish Parliament and the Northern Irish Assembly, is regulation in terms of wireless communication and data regulation and things like that, and that the idea is that they're caught by this defamation law reform. Scotland has said that really this is not an issue. It doesn't really go to the heart of those reserved matters, and therefore we're sidestepping it. Why was it not an issue for Scotland to get that Secretary of State consent for that?
Well,
and it would be for Northern Ireland.
Two reasons. First of all, Scotland didn't propose any equivalent of Section 5, so the matter doesn't arise. And Section 10 only touches upon internet services in a very tangential way, and that was the final view of the Scottish Law Commission and was broadly unchallenged as the bill made its way through the Scottish Parliament. Secondly, because Northern Ireland has a tripartite separation or outlining of powers between transferred, reserved, and accepted, Scotland simply has reserved and, in essence, not reserved. There are some sort of procedural ways in which matters that in Northern Ireland are designated in the middle category of reserved can still be legislated on by storm. And so in that sense, there might be a political way out. And the reason I highlight it here is because it has been the consistent position of the UK government that it would not legislate in respect of defamation because it was within the legislative competence of the Assembly. Now, if it turns out that a minor aspect of that legislation actually falls within Westminster's powers, and still the UK government would prefer the matter to be dealt with lock, stock and barrel in the Assembly, then there is a way in which that could happen. But of course, the even easier way is to abandon any attempt to do Section 5 in Northern Ireland, proceed on the basis of the Scottish experience, and in my view, the much easier argument regarding legislative competence. Now, I'm sure we'll go on and continue our discussion around whether an equivalent of Section 5 in Northern Ireland would be a good idea. I agree that it should not be part of the Northern Irish bill, but we may explore that further.
Well, that was the question, was, I'm not sure if that's what you had in contemplation, Andrew, that you foresaw that this difficulty, but one of the other thing that comes out of dropping that Section 5 and having this more expansive provision in Section 10 is that it maybe sidesteps this more constitutional issue about what is reserved matter and what is the legislative competence here in that sense. Is that correct then, that is maybe what the effect of dropping Section 5 would have here?
So the essential point, I suppose, is that data protection law will also apply in this area, and so what we'd be contemplating if we did introduce measures under defamation reform would be two different systems of law applying to the same type of conduct, and it would be left in the hands of a claimant to decide, which way they prefer to proceed, perhaps going both ways forward. Under the proposal, which was in the 2016 Act, this is in part sidestepped. It leaves the terrain somewhat free to data protection law, but yet, as we've discussed already, it still leaves the door open to a claimant to seek a swift order from a court to secure takedown under defamation law. I mean, I do find it interesting that there's a question here about competence, precisely because, we've seen Scotland legislate. We have defamation law, which applies in this area in England, while also having data protection law, which applies to the same conduct. And presumably all we would be thinking about would be the emulation of a scheme, which is pretty much already in place in another one of the UK jurisdictions. What the Scottish have done is more or less what was prescribed in the 2016 Act. Now, there is still a potential overlap, as Daithí has suggested, because there was a sort of a residual provision whereby it would be open to a minister to redesignate an internet intermediary as a publisher and thereby bring them back within the framework of defamation law if there were circumstances which motivated that. So to that extent, you would still be talking about at least the potential for an overlap. I suppose what I'm saying more broadly is I don't think that the overlap is actually problematic in the first place.
You don't think, right, because you could just take the version that you had suggested originally in terms of dropping Section 5 and that sidesteps it to some extent and it doesn't really engage that issue?
Well, I mean, I think that if you had an equivalent to Section 5, then you would be very definitely into the territory of having developed regimes which apply to the same conduct. My proposal, the Scottish proposal, effectively limits the potential for overlap there, although it doesn't eradicate it altogether. I think that that's a preferable approach, but what we have to recognise is that the sort of duplication already exists in England, and so if, as a matter of competence, it's possible for the Westminster Parliament acting just for England and Wales to do that, then it would stand to reason that the same thing could happen here. But again, I'm not advocating it happens. I'm suggesting that there's a better way forward. But I don't see any sort of area of issue of competence if it was the desire of the Assembly actively to do that.
I think there's also the divergence across the United Kingdom, not strictly in terms of legislative competence, but in terms of the policy goals. I think we're already seeing that with the legislation that's just been adopted in Scotland. In my view, the provisions in respect of internet intermediaries that emerge from the Scottish legislation in the new sections 3 and 4 of that bill are considerably more fit for the decade we're now in than the 2013 Act provisions in Section 5 and Section 10. They're certainly not perfect, and indeed, as has already been said, the ability of ministers by secondary legislation to go back and have another go at who is a publisher, who is not a publisher, etc., is potentially quite far-reaching. But again, that's the compromise that the Scottish Parliament adopted. I mean, the suggestions made by Andrew Scott for Northern Ireland in terms of an enhanced version of Section 10 rather than Section 5 and Section 10 are very much reflected in the Scottish bill. In fact, the Scottish bill pushes them even further again in terms of the ability to go back and change it. So we're already seeing, purely in policy terms, a different approach to internet intermediaries being taken in Scotland. So once the competence issues are resolved, and I'd be confident that they would be, Northern Ireland even faces a choice there whether to go down the Scottish road or the English road. I think the Scottish road is potentially quite likely, not least because Andrew Scott's work informed it. And I would share the view that Section 5 of the English legislation has had virtually no impact. It's only comprehensible with very detailed regulations, and that will be a question for the Northern Ireland bill as well. If you're going to have a debate about adopting Section 5, then you also need to debate the regulations, because that took quite a number of months after the 2013 Act and set out in a lot of detail how this would actually have a practical effect on the operator of a social media site or a bulletin board or whatever the case may be. It's not being used, and it has zero impact on privacy, on harassment, on data protection, on a whole bunch of other areas. So it created a very detailed and very specific defense that only works for particular types of websites, only works in defamation, and only works in England and Wales. And so the question that I would ask in the Northern Irish context is whether following that model, duplicating that model, is the right thing to do, or is this actually an opportunity as was seized by Scotland and as was outlined by Andrew Scott, and as is being now considered in Ontario and other jurisdictions, to think about the balance of power and the incentives and the way of dealing with internet communications. Because Section 5 was a product of its time. It was a response to an argument that it was very hard for the operators of particular websites to know what to do, and it drew a line between sort of claimed and anonymous speech and tried to create a set of incentives to favour speech that could have a name associated with it and allow proceedings to continue. But it hasn't worked. And that's justifiable from the point of view of the UK Parliament in the early part of the previous decade. But the Northern Ireland Assembly is looking 10 years later on and gets to make up its own mind on this.
Right. And I mean, so Scotland offers a way forward there in that respect. And I mean, but there's one other question there is, you know, what you said is Section 4 of the Scottish bill, which suggests that, as you stated there, that the ministers can go back and they can create secondary legislation in order to make further definitions in relation to intermediaries. You don't see that. Is that something that Northern Ireland should emulate? Is that going too far?
I think it's a very interesting proposal, and I understand why it's in the Scottish legislation, because the way in which the Scottish Law Commission and Parliament took the core of Section 10 of the 2013 Act and expanded it to make it even harder to bring an action against an internet intermediary, that then quite reasonably faces the counter argument that you've now made it too easy for the intermediary to do nothing. And indeed, Section 4 of the Scottish legislation, you know, is explicitly justified as saying, look, if this turns out to be a big problem, if we have gone too far in the speech direction and created a type of impunity for powerful social media operators or particular contexts, then they can be brought back into the picture, albeit with defences and so on. And that's the trade-off that's faced here. This is why, for instance, although many have suggested it over the years, no legislator in the UK has ever gone down the categorical immunity from defamation that we see, for instance, in the Communications Decency Act in the United States, of saying to the host in particular, you know, you can throw those letters in the bin, because the consequences of that from the point of view of reputation and the protection of individuals was a factor. And that certainly arose in the committee debates in Scotland, that on one hand you try to make it easier for operators to defend speech and to provide a platform for the views of others, but you still reserve this idea that if there is abuse, if there is a problem, that you would still be able to offer some protection of reputation. And that's my understanding of how Section 3 and Section 4 in Scotland work together. Again, not saying it's perfect, but it's something that the Northern Ireland Assembly should give particularly good consideration to, especially in a time of discussion around online harms, around the power of intermediaries, as has worked out in the United States over the last couple of months in terms of account deletion and the like. So it's a big question that the Assembly will need to face, and it will need to face it from a 2021 perspective rather than a 2013 perspective.
Yeah. And I mean, I asked the question, you know, what's changed since 2016? And immediately we come to this issue about, you know, the growth of online communication and the challenges that presents. And, you know, immediately you come to even to this issue of legislative competence. But let me ask you, Daithí, I mean, more generally, what do you see as the issues arising from the growth of online communication and the technology since 2013, when it was really considered in England and Wales? What are the issues now that any legislature, and particularly Northern Ireland, needs to contemplate as they consider reform of defamation law?
The issues are still there in terms of the ability of platforms to moderate, for instance, how they apply their own terms and conditions, how responsive they are to complaints, and bearing in mind that by now many of the large platforms have developed quite elaborate systems for dealing with complaints, reporting mechanisms, flagging, use of automation, and so on. So there's a lot more scholarship now on how moderation works in practice and what types of things are taken down or are not taken down. I mean, it doesn't address that fundamental structural issue that the incentives are still there to take it down, if there's any doubt at all, because there's very little for platforms to gain from leaving things up, other than their image as defenders of speech, or their desire, to attract users on the grounds that they won't have their stuff taken down straight away. But we still see great investment by social media platforms in particular in enhanced forms of moderation. We also see, of course, again, over the course of a decade, the continued success of different forms of social media, not just the bigger names as was then of Facebook, etc., but of newer platforms such as TikTok, which are audio-visually rich, which deal with different types of material, which again see an overwhelming volume of content where pre-moderation is not possible. And we've also seen, as I hinted at earlier, discussions around what the responsibilities of these platforms are. So one of the criticisms leveled at social media operators in the US was that they were being judge, jury, and executioner when it comes to speech, that they were protected against liability, but could also decide to favor or disfavor particular political speech without any realistic recourse from those who are penalized by it in that way. So, the importance of that decision to leave up, to take down, to stay down, and so on, has become a subject of great emphasis. And we see, for instance, at European Union level, a lot of work going on around harmful online speech, around the responsibilities, around setting targets for things like how quick hate speech is removed. So the spotlight is upon operators of websites more so than it would have been at the time of the 2013 legislation, where the clearer lobbying and the clearer argument was, look, give these guys a break. All they're doing is providing opportunities for speech. Perhaps our optimism maybe has changed a little. There's maybe a more jaundiced view on the power exercised by these bodies, as well as how difficult it is to have material removed. But I would also agree with what Andrew Scott has said around the timeliness here, because when Ontario started to look at this, it looked at notice and takedown models from around the world, but fundamentally, ways of speeding up disputes in relation to online material will have much more of an impact than kind of carefully balancing the liability or the defences that might be available much further down the line. Having ways in which orders can be issued to have material taken down, having rapid resolution, low cost resolution of disputes is much more significant for internet communications than it is for other areas of communications and media.
And how does that correlate with this view that we often get presented to us in the media, that social media giants, and indeed they're regulating speech themselves now in terms of what they deem to be fake news and things like that, the immense power that they have, that we don't typically, one of the changes that we see is we don't typically see them as being these people that we got to give these guys a break. These are people with a massive power and with massive public responsibility in terms of speech now.
But it's possible that both of these points can be true. These can be intermediaries vested with great power and responsibility, but also the law is a mess. I mean, Andrew Scott has described the range of available defamation defences that an intermediary can avail of as an unwholesome layer cake. I've described the picture looking horizontally across defamation, privacy, intellectual property, and data protection as a fragmentation of liability. And so there's uncertainty, there's risk, and in terms of what the legal system is doing, it creates incentives to remove material when somebody is shouting loud about it, when it looks like this is going to be difficult, when there's kind of tacit political pressure to be doing something. And again, when I presented on this, I can go through multiple speeches, threats, suggestions that social media should be doing more about this in the absence of clear legislation. And so again, the overwhelming direction of travel has been towards a responsibility driven agenda. So in the face of a responsibility agenda and a lack of certainty as to what defenses arise, in many cases the operator of a website will take stuff down. They may not be taking the right stuff down, so this is often the problem. They may be taking it down on a basis of risk or on a basis of perceived importance, politically or otherwise, rather than actually thinking about harm in any serious way. The scale of the material and the way in which moderation operates suggests that this is not a careful calibration of harm, but more a response to a series of pressures and incentives.
Let me ask you, Gavin Phillipson, was that also your impression in 2013 when the UK Parliament was considering reform here that they should give these guys a break and internet intermediaries and this idea that maybe we should still give them a break in any sort of fashion and legislation should be drafted to that end?
I mean, I think I saw Section 5. I mean, I haven't kept up with how it's been. If it turns out it's kind of been useless in practice, then fine. I thought at the time it seemed a reasonable attempt to try and strike a balance between kind of, two extremes. You've got the US extreme model at one end, which is basically a completely free pass for intermediaries, even when they're notified that they're carrying seriously illegal content, that CDA 230 that Donald Trump dislikes for the wrong reasons. There's very good reasons to dislike Section 230, which are not the ones that Trump has. So that's the kind of extreme free market, free pass, essentially. And on the one hand, a kind of strict old-fashioned model that would basically, at the most extreme end, would treat an intermediary as a publisher. So it's an attempt to basically find some middle ground, which is broadly represented also by the e-commerce directive, that essentially once notified of potentially unlawful content, then you may come under some duty to remove it, or Section 5 gives the other option of basically allowing the complainant to sue the poster directly, which I can imagine will very often be impractical on it. So I can sort of see why that provision hasn't really worked. But I kind of liked it in principle, but I would defer to these guys in terms of if it hasn't worked out in practice. I would understand why. But I mean, that some kind of middle ground has to be found, I think, both for the purposes of the e-commerce directive, which I assume is EU retained law and still therefore sets our basic standard, and also as far as Strasbourg is concerned, and balancing Articles 8 and 10, which would not permit us to have anything like, I don't think anyone's suggesting it, but anything like CDA 230, for example, or indeed a very strict liability of intermediaries. Although, if anything, I think Strasbourg has erred a little bit on the side of being overprotective, I think, and underprotective perhaps of intermediary free speech, I would think, from the case law. But
okay. Well, one of the things that certainly happened with the growth of online communication is an explosion of what you might call low-value speech, and it certainly made it more accessible for people to publish things and publish them to a wide audience. And that relates to a question I have, about where public interest and what we might call more high-value speech fits into this. And that's a question I have for you, Gavin. I want to talk about free speech and public interest reporting, because I think in this whole complex milieu that we find ourselves now in, that public interest speech is something of a baby in the bathwater. And Northern Ireland is a post-conflict society with power sharing and political representation along sectarian lines. And with that, it depends a lot on government and public power. And as we saw with Brexit, that's a very broad basis of a political framework. And then at the same time, we have a relatively small and modestly resourced media sector. The question for you is, in this whole complex milieu we find ourselves in now with online communication, what kind of protection in law should we expect of free speech and debate on matters of public interest? And is reform necessary to protect that?
I don't think it's completely necessary. I think the common law had kind of got to a point where it was striking a reasonable balance, but I think that legislation can be very valuable in giving a much more clear and explicit and easily understood affirmation to journalists in particular of the protections that they have, rather than expecting them to kind of, which they obviously won't actually read the case law, but read some simplified guide to the case law, which is the best that they'll get. And we were discussing on email, that lawyers acting for media outputs have found that Section 4 has made, a bigger difference than I would have expected it would have done just looking at the law, and that possibly is its kind of communicative value, that having it set out clearly in legislation that then itself attracts a lot of publicity and debate, just means that everyone is kind of clearer, even if the change to the law is not that significant, which I didn't think Section 4 was, although I think the case law has perhaps meant it, the latest case law, Serafin in particular, from the Supreme Court, has meant that it's probably a more relaxed standard, I think, than it could have been interpreted as. But in terms of public interest in relation to sort of, potentially defamatory speech, I do not think Section 4 is a good model, and I wouldn't recommend that it be used. I think the original draft of Section 4 which is, I think, much closer to the kind of Commonwealth consensus, particularly in say, the Canadian Supreme Court decision in Grant and Torstar. So the essence of it is responsible communication on a matter of public interest, which was kind of what the original draft of Section 4 was. I just went back to check it out. So the original draft of it was that the statement complained of to qualify for the defence would formed part of the statement on a matter of public interest, and the defendant acted responsibly in publishing the statement complained of. And then the original draft of Section 4 had a kind of checklist that looked very much like Reynolds. And I understand the issues with checklists and with courts treating them as, kind of 10 hurdles that have to be overcome and too rigid about them. And I think, I'm sort of half persuaded by that. But I do not think that removing the wording of the defendant having to act responsibly in terms of making, basic checks, making a reasonable attempt to verify seriously defamatory allegations before publishing them is a good idea. And I note with concern that the Supreme Court in Seraphim has taken quite seriously the removal of references to acting responsibly, and says that because Parliament deliberately chose to remove those words, that the courts can't use them anymore. And the paragraph that you pointed out to me from Seraphim, where the Supreme Court says essentially that references to acting responsibly should be avoided. So what matters is the defendant's belief that they have acted in the public interest in publishing the material, which also I just think adds an unnecessary layer of complexity. What we want is, we do want protection for statements that turn out to be false, provided that because if they're on matters of public importance, because for one thing, they may be true, and it just may be that we can't prove them true in court, as some of the cases revolve around, where in fact the allegation probably is true, but the evidence just can't be found or can't be adduced in court. Or it may be that it was a very important matter and that it was justified in publishing it, even though it turned out not to be true, because the paper had made reasonable attempts to verify it at the time. And I don't think they should be punished if it turns out that they got that wrong. Although a good compromise would be, which obviously Andrew's talked a lot about, to have a discursive remedy in that case. In other words, that they shouldn't be liable in damages. But if the matter turns out to be false and is damaging, but it was seen as in the public interest to publish it, then they should, while benefiting from the defense, they should benefit from the defense only if they acknowledge in their publication that actually the allegation turned out to be false. Which again was there was much talk about this, and this was in an early draft of what became Section 4 of the Defamation Act, but then disappeared, and I don't really know why it disappeared, unless it was just pressure from the media that didn't obviously want it. So essentially, I think when you're talking about defamation, those two elements, that the topic is a matter of genuine public interest, and I think there's plenty of definitions in press codes around of kind of non-exhaustive lists of matters that are on the public interest. I don't think you can define the public interest in statute, or at least certainly not exhaustively. You can give non-exhaustive, quite short definitions, and really it'll come down to what the courts make of them. But I do think those twin elements, that the topic or matter or substance of it is genuinely of public interest, and that there is a reasonable attempt at verifying the allegations. And it may be that Section 4 kind of more or less sort of says that, but I just think couching it all in terms of the defendant's belief that they were acting in the public, or the defendant's reasonable belief that they were acting in the public interest is just a really strange and convoluted and unnecessary way of getting there. Why not simply say that they need to have acted responsibly, and that is assessed, with due regard for editorial, for editorial discretion, and with the pressure of modern newsrooms and all the rest of it. So there's some deference from the courts in deciding that point, and that should be said in the statute, as Section 4 does. But I just don't think the wording that Section 4 ended up is very helpful. Though I'm glad to hear if it sort of made more difference to the press in a good way than perhaps we thought it would. But I just don't think that particular form of wording is a helpful way of capturing the responsible journalism part of that defence, which is a kind of common defence throughout the Commonwealth. Responsible publication on a matter of public interest. I wouldn't use the wording of Section 4 as it ended up.
Well, what is communicated by journalists sometimes is that Section 4 has a psychological value. It's a statement, it's a clear codification of public interest defence, and what we had in Reynolds before that was this it was open to judicial ambiguity, and it had this non-exhaustive checklist. But when you look at Section 4, and as you say, they did drop this provision about it being responsible. But what it does have is, the stipulation that it has to be a statement of public interest, as vague as that is, and then that the defendant acted reasonably in publishing the statement, and that, when you look at the case law around that part 4.1b, it's quite a high standard still, in terms of it's an objective and a subjective test, whether or not there was a belief and whether or not there was a reasonable belief. I mean, what we don't have is, this is not approaching like a New York Times and Sullivan type of standard. We're not going that far. And the question is, does it not still, if you look at Section 4, it still, provides quite a high standard for publishers to overcome, in a sense, and when they're publishing those kind of stories and public interest stories and what they claim to be public interest stories?
I mean, if it is a high standard, that's only because the courts are reading that into it. All it says is the defendant has to reason. It doesn't say the defendant has to act reasonably. It says the defendant has to reasonably believe that publishing the statement is in the public interest. And as Andrew and others, and Alison Mullis and others pointed out at the time, in principle, that could be, you could have that reasonable belief just in the sheer importance of the topic, and could think, well, we're really not that sure whether it's true or not, but this is just such a big topic, we just thought we had to get it out there. That could be a reasonable belief it was in the public interest. So you have to kind of heavily gloss that reasonable belief and read back in the requirement of kind of responsible journalism, of making reasonable attempts to verify, in order to make it a reasonably high standard. So if Section 4 has that, that's only because the courts are busy still kind of reading it with a heavy gloss of sort of Reynolds, although good that they've adopted the overly rigid prescriptive approach to the Reynolds factors, and it may be that you don't want to list them in the statute because that makes it too rigid. But essentially that particular wording, where that very indirect, convoluted way, you have to sort of read in responsible journalism if that's what you want, which we know that you do need that to satisfy Article 8 of the Convention. So it's sort of going to have to be read back in. So in that way, if you know the judges are going to do that, why not try and set it out yourself? I mean, the whole purpose, as you said, Mark, the reason why journalists find this helpful is because it's there in kind of plain black and white in the legislation. The trouble with this is it means a lot more than it says. So why not just make it mean what you want it to mean? Why not just set it out clearly, like Grant and Torstar, for example, where you've got two requirements. First, the publication must be on a matter of public interest. Second, the defendant must show that publication was responsible in that he or she was reasonably diligent in trying to verify the allegations. I mean, that seems to me to be just much clearer, and it's there on the page, instead of this kind of convoluted, indirect way that you have to kind of gloss what Section 4 actually says with, oh, well, of course, what that really means is you can only have that reasonable belief that it's in the public interest if, in fact, you've acted reasonably responsibly. I just think that's not a good way of getting what you want, getting where you want to get to.
Well, the difference, as we saw in the judgment of Sarah Finn, was really that there is some kind of distinction between what responsibility entails and what reasonableness entails, and there has to be some kind of editorial allowance, as it comes in Section 4.4. I'm just wondering, Andrew, what's your take now on Section 4? Because in the recommendations in 2016, you were pretty much in favour of Section 4. Do you still see it as being not problematic, or do you see any issues with it?
Okay, there are a number of different sort of ways into this conversation, I think. I mean, one thing, just to begin with, if we look at what's been legislated in New South Wales, what they have done is also put Reynolds onto a statutory footing. But in contrast to what we've seen in England and Wales, they have gone through the process of identifying, Reynolds type factors and listed them explicitly. Now, my reading of that was that the Australian legislators, when trying to bring Reynolds onto a statutory footing, were obliged to include that listing because they don't have the equivalent of the Article 8, Article 10 balance in the constitutional background. For my money, the Section 4 is to be read as the equivalent of Reynolds and not something more like New York Times and Sullivan. Certainly, judges Mark Warby, the Court of Appeal in Serafin, both emphasised the idea that was the appropriate reading. Where there tends to have been a bit more of a sort of nuance introduced in the interpretation of Section 4 concerns publishers who were not sort of mainstream media. And in those regards, there's been a slight extension and a slight amelioration of the strictness of Reynolds as read through the terms of Section 4. I mean, I'd like to come back to a couple of things that both of you have said there about the availability and desirability of Section 4 from a journalist perspective. I mean, I'm not a journalist, but I'd imagine that it's helpful to have something like Section 4 setting out the basic expectations and allowing journalists and their editors to understand like when they'll be able to proceed and when they really shouldn't proceed. But I think it needs to be recognised that whenever you get into legal action, whenever you're involved in litigation, Section 4 really, and Reynolds in the past, really doesn't serve the journalist very well, because all of a sudden you're shifting away from a focus upon the veracity and accuracy of what has been published and the significance perhaps of the allegations that have been made. And everything then refocuses upon journalistic conduct, So the pressure being brought to bear upon the media publisher at that stage must be enormous. You're certainly the way the defence was interpreted by some English judges required such a sort of perfect performance that it was very rare that actually Section 4 was effective in defending journalism. So I mean, the hope.
Yeah,
Sorry,
I agree with that.
Yeah, okay.
But can I just put to that, that yes, that might be the case, but it's, in a sense, it's getting lost in the legal abstraction of this, and it may be the fact, and from what we've heard, and there's different accounts, but it may be the fact that just codifying, a Reynolds type defence and simplifying it and putting boundaries around it the way that Section 4 does, maybe not perfectly, but that has that psychological impact, and it means that cases don't even get to court because journalists feel more confident in publishing things, and also claimants feel a little less confident in bringing claims against those.
Yeah, I'm sure that is the case. And if we draw the sort of analogy with data protection law, where sort of proper mainstream journalism, which is met with a complaint under data protection law, which is increasingly the case alongside defamation, in those contexts, mainstream publishers have found it very easy to simply refer to the public interest defence available in that context to dissuade further action. The main point I suppose I would like to make is that ultimately I think, as Daithí has said earlier on with regard to internet intermediaries and internet publication, we need to think a little bit more about the complexity and the what's the right word, the overextended nature of the legal process that becomes in which people come embroiled here. Because if you involve yourself in a defamation action, you may well find yourself fighting that defamation action for several months, if not years. And very often, the importance of the issue is just the importance of the journalism is just completely out the window and completely being ignored. Now, wouldn't it be preferable if some means could be devised in order to ensure that most disputes, and by the way, most disputes are based not upon necessarily the poignancy of what has been published, but about sort of picking around the edges of what has been published. People suggesting, well, you said X, Y, and Z about me, but actually that's not true. And then the response is, well, we didn't actually say that about you. We only meant to say Y or Z, and we think that probably is true, So we're sort of transposing like a public sphere dispute, from the public sphere into a courtroom where it becomes reified and expands massively in terms of the time and resource that it takes to resolve. It might be preferable if we could find means of quickly, by providing a legal framework within which this could happen, but quickly resolving disputes and leaving only those disputes which are absolutely intractable, where some very straightforward black and white allegation has been made, which the claimant contends simply is not true, and where the impact on reputation is so significant that it really must go through a legal process in order to reach an adequate resolution, and perhaps punishment for the publisher.
Well, this brings me to something I also wanted to ask you about, and it's your recommendation of more discursive remedies. that was put forward in the 2016 report. Can you tell us a little bit about that and the recommendations that were there, and whether or not you still see those as viable? And is that the answer that you're grasping towards here?
Well, again, there are sort of layers in this discussion. I mean, we've seen the operation of a discursive remedy very recently in the context of Meghan Markle's privacy action against the Mail online, albeit that this was an action brought, at least in this respect, in copyright. I mean, the judge found in her favour and is compelling Mail Online. I mean, I think obviously this is subject to appeal, although the first instance judge has denied their right to appeal. He's compelling them to put a front page recognition, if you like, of the fact that her copyright was breached, and for that message to be conveyed for a period of time, from recollection, I think it was 7 days, on their online sources. So that's a discursive remedy, if you want, an apology or correction or clarification of what has actually happened. Now,
and it'll be interesting to see how that plays out in the Mail on Sunday, and what form that takes. But yeah.
Well, sure. Look, I mean, the other thing to say is that in accordance with their own standards, the editor's code of practice, newspapers by and large are committed to correcting significant error as soon as they come across it. Whether they actually do it or not, or whether they do it adequately from the perspective of the complainant, is a different matter altogether. And this sort of the availability of this type of remedy in copyright is not an entirely new thing. The point I was going to make about it is that the 2013 Act expands upon discursive remedies, makes them certain types of remedies more available, but they all come into play at the end of the litigation. If you win your case, then you get the remedy, and that's a good thing in its own right. But it doesn't sort of speak to this sort of desirability of quick resolution, early circumvention of the legal process, or short circuiting of the expanded nature of the proceedings. What was proposed in the first bill, Appendix 1, I think it was, in the 2016 Act, was a sort of a slightly more nuanced idea. I mean, what it would do would be profoundly to encourage very swift retraction and correction, where what was published was ambiguous. Okay, so most of the time, a journalist will have a specific allegation they want to make, and they'll put it down, and it will be easily interpretable. But sometimes what is said, I mean, particularly if you're thinking about longer form journalism, or even criticisms which might appear in 1 hour broadcast specials, or even in book form, is that you get sort of multiple layers of allegations and complexity of assertion being introduced. So where somebody comes forward with a complaint, the idea would be that the first thing that they would seek to do would be to clarify the nature of the allegations that were being made. And where ambiguity generated misunderstanding, corrections or retractions of the ambiguous meanings, the unintended ambiguous meanings, could quickly be entered into the public domain. And everyone would know from the outset, perhaps within 7 days, that the allegation which the claimant has perceived as being there was not true. Okay? But by the way, if the journalist did have another point which should be dealt with by the claimant, or maybe should affect the reputation in the public sphere, that can still be sued upon. Okay, so we move very quickly in the direction of clarifying the nature of the dispute. Okay, but we do that without having to go through the rigmarole of preliminary hearings in the High Court, which is extremely costly. I mean, there are now limits which have been put upon preliminary hearings and the determination of meaning, but the limits are £30,000 per side. We're told that this is a very swift process, but in fact, on the basis of some research I've conducted recently, it's more like 600 days on average to get a court-determined meaning of the publication that was originally causing the harm. So the alternative available when you retract or correct is to clarify the dispute and to do it more or less immediately. And that's easily facilitated, by putting the sorts of corrections or retractions that the Mail is now being compelled to do at the end of the process, putting them in the same sorts of locations on websites. Sources to which then a claimant can refer anybody who wants to continue to believe in the alleged falsehood or the ambiguous treatment. So that to me seems to be the type of resolution that we need to be thinking about, much more than revising perceived nuances in defamation defences. They remain for the case where I'm alleging that something is true, and you're contending that it's false, and we really need to get down to the nuts and bolts of the evidence to determine that. But by and large, most cases would just be determined swiftly and to the satisfaction of all parties concerned.
I mean, one of the things that really came out there is if you, and I'm quoting you, Gavin, is if you're going to legislate, you have to get it right. And then what Daithí said, it's not completely possible maybe to get it right. And this is something that we see in defamation law a lot is, it's a very fine balance between the right to reputation, right to freedom of expression, and it's very hard to strike that balance, and we perhaps have to accept some imperfection here. But the question keeps coming back to, is it legitimate to throw out any kind of expectation that we will have a protection of public interest speech just because it's difficult to do so? And that comes also, I wondered about the discursive remedies discussion and what you have suggested, Andrew. This idea that, as I read it, what you were saying, Gavin, is that this is given too much. This idea about corrections and retractions is given too much leeway to defendants. Was that your position?
No. I mean, I was agreeing completely with Andrew on that. I think that's where we should be going, and we should be much more, innovative and creative and encouraging those, which is kind of what everyone wants. Newspapers don't want lengthy, enormously costly proceedings, and claimants don't always want loads of damages. They want this very damaging insinuation about them that, to be very quickly corrected. And then they're kind of happy. Most people aren't actually after, protracted legal proceedings and with the hope of getting tens of thousands of pounds of damages at the end of it, although a few people may be. I do think so. I mean, I absolutely think, by the way, that we need strong protection for public interest journalism. We absolutely do. So libel law was used to shut down, as we all know, things that needed to be aired over and over and over again. So that it's very, very important. I just think if you want, or I think the narrow point I was trying to make is that if you actually want it to include some requirement, but a flexible, requirement, and also one that can be applied to non-professional journalists, which I agree is an important feature of Section 4, whereas Reynolds was heavily, almost exclusively kind of aimed at professional journalists. So if you want a kind of broader defence like that, I just think if you want to have some requirement that they must have made a reasonable attempt to verify the allegations, then there's just a clearer way of saying that. I just think that 4.1b is just a really convoluted, indirect way. And the other point I wanted to add is it's almost willfully confusing. So subsection 6 of Section 4 says the common law defence, known as the Reynolds defence, is abolished. And then, as Andrew noted in his article in the Modern Law Review, the explanatory notes to the Act helpfully say the new defence, Section 4, is based on and is intended essentially to codify the common law defence, while the current case law would constitute a helpful, albeit not binding, guide to interpreting how the new statutory defence should be applied, which I just think is... So we're abolishing a defence, but actually we're also codifying it at the same time, and the case law is helpful, but it's not binding. I mean,
well, one of the things it does,
setting out to confuse everyone with that. I mean, great if it's turned out to help a lot, but it's almost like they did their damnedest to make sure that it wouldn't help.
But maybe it's the explanatory notes, sir, because one of the things that came out in the case law is that the defence can't be equiparated with the Reynolds defence, that it's got rid of that baggage of the qualified privilege, and it's worthy in that sense to distinguish it and to maybe abolish the Reynolds defence for that alone.
Well, yes, abolish the Reynolds defence and don't have that explanatory note. But then, if you want to have responsible journalism, maybe you don't want to have responsible journalism. Maybe you just want to say, if the topic is important enough, it doesn't matter, don't make any attempt, just put it out there. I don't think that's what we want, and I don't think that you can actually do that under Article 8. But so assuming that you do want some requirement, but not an overly onerous one, not judges dictating to journalists how they do their jobs, but just a sort of reasonable journalist test, then just say that. I don't know why Section 4 the wording was used. I just don't think it's a helpful way of getting at it. It's just too indirect.
But Section 4.1b does actually explicitly say reasonable, and we know
reasonable
that means...
belief that it's in public interest.
Reasonable
belief, not...
Yeah.
So in other words,
the distinction here, of course, is between the reasonable belief that it's in in the public interest and, for want of a better term, reasonable conduct. So the
Yes.
behavior of the journalist or the blogger or the tweeter does not itself have to be in any way reasonable. In fact, it can be
No.
it can be exceptionally unreasonable. But it's the belief regarding the public interest that's the turning point.
Yes.
Now, again, that's something that maybe reflects a move away from some of the policy aspects of Reynolds. It's always difficult talking about the policy aspects of a judicial decision designed to give effect to human rights standards. But at its best, what Reynolds and its treatment in the common law world seeks to do is to promote responsibility in media and to reward a high quality approach, whether that be putting something on the front page of a long-established Sunday newspaper or an investigative blogger doing a tell-all. That's why, for instance, when we talk about things like discursive remedies, which I'm a strong supporter of, we run the risk sometimes of taking on board a press narrative around regulation. I mean, we know that investigative journalism thrives in the audiovisual media sector, despite rights of reply being there as a matter of statute in many EU member states. We see the role of Ofcom, and I know I've often been critical of Ofcom as a regulator for various ways, and it does have a different role because of its license awarding authority. But we see many people who are unhappy at their treatment in the audiovisual media being quite satisfied with what you would think of as a discursive process through the broadcast complaints mechanism. And we see in other areas attempts to try and take the best of audiovisual and electronic media regulation and finding a way to make that work for video sharing platforms or video on demand services and so on. So there was that nugget in Reynolds that actually encouraged us to think about the links between private law and media regulation in a more explicit way. Section 4 kind of cuts off that and brings it back to perhaps a more conventional human rights narrative, which is extremely important in terms of press freedom, but doesn't necessarily get that responsibility and standards conversation going in a way which all of us have touched on in various aspects so far in this discussion.
Yeah, I agree it would be somewhat submerged within Section 4, because of the language which is used. But the way in which it's interpreted is ultimately to say that a journalist or somebody in that position, where they're engaged in what you might describe as like proper investigation and proper journalism, could not hold a reasonable belief that publication would be in the public interest if they hadn't gone through the process of vouchsafing the accuracy of their allegations, by dint of standing up the story by through proper journalistic conduct.
So you're saying that 4.1b suffices then to protect responsibility?
Well, the debate was
you have
always,
to read that in. That's the point.
Yeah, the debate was. I mean, look, the new version of Section 4 was introduced effectively at the behest of the libel reform campaigners, who were hoping that it would be interpreted in a manner equivalent to New York Times and Sullivan. So that essentially, if you were writing about a matter of public interest, then you'd be effectively absolved from potential liability unless the other side could prove that you'd acted with malice, i.e. like a reckless disregard for the truth or falsity of what you're publishing.
Yeah.
So, I mean, whenever this was introduced, immediately various people spotted that that's where that defence was going, and therefore made various representations through various different devices to ensure that the government offered a pepper and heart statement to the effect that, no, this was not intended to be an equivalent to New York Times and Sullivan. It was intended to be a statutory version of Reynolds, Now, hence, that's why it's interesting what's happened in New South Wales, because they, don't have the constitutional framework. They have to make that very explicit, and that's what they've done. Now, there's still then a question about whether that's how it will ultimately be interpreted by the courts. And my understanding is that the courts, by and large, have insisted upon that in cases involving journalism. Now, it might be that a door is opened by, particular paragraphs in Serafin and Malkovich, to an expansion of this defence. And it was noteworthy that one of the counsel who was arguing that case took from the judgment the idea that this had been expanded to become something more like a generic public interest or public figure defence as we see in the United States, which I didn't see there. But I mean, the door appears to be open for future council to
I mean,
that.
I think that's really interesting, and Andrew reminding us kind of the background, because the government was under huge pressure from the libel reform campaign and the press. And they were also themselves rather foolishly kind of going around saying how terrible English libel law was and saying this was a huge change, when in fact it was actually a series of very, very modest changes. So they'd kind of painted themselves into a bit of a rhetorical corner. And Section 4 was a fudge. So Section 4 was designed to make it look to the libel reform campaign, look, you might get a really big, bold change. And then a quiet pepper and heart statement, explanatory notes, no, don't worry, it'll be fine. It's really just going to be Reynolds. So why would you adopt what was always a fudge that was designed to almost give an impression of something that was of a much bigger change than it really was, with the experts knowing, but don't worry, they'll read in Article 8 stuff and they'll read in Reynolds type stuff to mean that really you have to have responsible journalism, even though it doesn't say that. Just say it. That's all I'm saying. If the whole point is clarity and giving journalists a toolkit and they can just sit down and read it, which actually I think is one good thing about Section 3. There's some details I don't like about Section 3, but at least it says these are the three things instead of this really complicated case law that you had. So that's great. If I was a journalist on some little small publication with no lawyers and no insurance, and I just wanted to be able to quickly look at it, I would love Section 3 compared to the case law, but I just think Section 4 is not good in that way. I just, just write down clearly what you want the standard to be and put it out there. Don't have it having to be read in by and argued over by appellate courts for several years before you figure out what it finally means and how much it's changed Reynolds.
And Gavin's point there is very important, that we, in the Northern Irish context, because although I can see the clear arguments in terms of the smaller scale and consistency and the uncertainty and risk that arises out of varying standards, the 2013 Act was not adopted in Northern Ireland at the time of its passage, and that is now history. Andrew Scott's report identified many aspects of it, but made a number of recommendations for change. The Scottish legislation, in various regards, goes further as well, and so the debate in Northern Ireland will need not to be focused upon the copying and pasting of legislation that was very much a product of its time. Aside from our earlier discussion around technology, 2013 was that culmination of a long-standing libel reform campaign and the kind of the fallout of the press standards and regulation agenda. And the government of the day was facing various pressures in order what was in and what wasn't in the legislation. But I'm not sure the UK government would make all the same judgment calls today if it was doing libel reform. I'm certain the government in the Republic of Ireland, which is facing into this again, will be able to benefit from changes on that. So Northern Ireland, although it will want to maintain some consistency given its common law legal system and given the small scale of the media, will need to look carefully at these provisions, separated from some of the pressures that were exercised in the parliamentary debate in 2013, which are simply not present in the same fashion as they were then.
And what's interesting is that Scotland, as I understand, considering that they are at this stage now of, final amendment stage, they have largely adopted. Section 4, they've gone for Section 4, Section 1, they've more or less gone for, and they've heard all of these objections, and they still see that this is essential for protecting free speech. And even in this context today, that they're still going ahead with that. But I think you're right. There's definitely complexities there. I wanted to just mention two things. Is first of all the case of Doyle Smith, and reading Doyle Smith, what you see is actually this 4.1b and the reasonable. It does, as you suggest, Gavin, it really comes out that it is a requirement of responsibility. But then if you look at Sarah Finn, and responsibility was seen as going too far in Sarah Finn. So it seems that it's almost like somewhere between reasonableness and responsibilities where you have it, and then you don't get the language in order to do that. But
if 4B even said the defendant reasonably believed that he had acted responsibly in publishing the statement. So that takes you back a bit from. I get the idea that you want something that isn't the courts kind of just themselves deciding what is responsible journalism, because they need to. They're not experts in the area, and they're not acquainted with kind of the pressures of modern newsrooms and all that. I get that. It's just that the wording is not very helpful for that. If you had the defendant's reasonable belief that he'd acted responsibly in publishing the statement, fine. At least that'd be closer to what you want, and it helps take you back from the courts deciding themselves what is responsible journalism and kind of, a sort of reasonable journalism standard instead. I think that would be fine. It's just reasonable belief in public interest. You don't have to say, you could only have that reasonable belief if you also reasonably believe you'd acted responsibly, because it's not in the public interest to publish. You see what I mean? There's just an extra stage of reasoning that isn't in the wording of the legislation that has to be kind of added in, partly from the common law and partly from from Article 8, to sort of get you to what it actually means. And even then, you're hovering somewhere between a responsible journalism test and a reasonable belief in responsible journalism, or a reasonable belief in public interest that can only be produced by responsible journalism. So I imagine the courts are going to go back and forward on this, and it'll depend a bit on the facts of the case, as it always does, and they get to the result that they want, as we all know. But yeah, even with the cases and the way they've gone about it slightly differently, it suggests to me that it's not a very clear thing for the courts to have to grapple with.
Yeah. I want to talk a little bit about discursive remedies before we talk about Section 1. And we touched on this already, discursive remedies, and that was really central to your report, Andrew, in 2016. And from the discussion there, it was a little bit like, I get the impression a little bit that the retractions and corrections is maybe there for defendants, and it's coupled, isn't it, with this idea that there has to be a repeal of the single meaning rule. And is that repeal of the single meaning rule as being as a balancing out of that, and is seen as giving something to claimants and making it easier to bring claims in that sense? Is that how you envisage it?
Yeah, so I mean, in general terms, the idea was to try and sort of narrow down the issues very quickly, so that only core disputes ever went anywhere near the court. Okay, so as you say, the basic proposal was to A, withdraw the single meaning rule, and B, provide for a jurisdictional bar to actions being brought if a retraction or correction had been introduced promptly and prominently. Okay, so the idea would be that where there was sort of an ambiguity of meaning, any sort of misinterpretation by the claimant and potentially by other people who hear the statement would be quickly addressed, such that if there remained a dispute, that could go on into the legal process, and if the dispute was resolved on that account, then that would be the end of the story. Okay, I mean, it was very interesting at the time I expected this to be received as being far too generous to defendants. That claimants would effectively be frustrated in their desire to seek a remedy and damages, and that the policy objection would come from that side. In fact, the complaint about it came very much more powerfully from the media side. And we were presented with a vast array of different arguments as to why this wouldn't work, was inappropriate in concept and inherently undesirable. To my mind, this all boiled down to the fact that the media didn't want to have to correct or retract minor errors every time they arose, and that was essentially because these minor errors arise all the time in every publication. So their concern was the risk of death by 1,000 cuts. I mean, they much preferred the potential to defend themselves in the one nuclear action that ever reached the court under traditional defamation law. I mean, I think there's been some amelioration in that perspective from the media. I think they perhaps, or people who I've spoken to from within the media, I think they maybe understand the premise a little bit better now than they did in 2015, 2016. But it's still there. I mean, what this would require would be ultimately a sort of shifting in the underpinning culture of defamation law. The high stakes casino royale version of reputation management.
But is it hard to discount those media objections, though, considering the fact that it's coupled with this repeal of the single meaning rule? Because is there a chance that this repeal of the single meaning rule essentially makes it easier to claim because the claimant doesn't. I mean, that determination of the single meaning rule and whether a reasonable reader would understand it of that and all the qualifications of a reasonable reader, that provided some bar, didn't it, to claimants? So in essence, then we have to be really careful about these discursive remedies, and there has to be an exact balance struck in that sense. And if we get media representatives saying, well, we're not sure about this retractions and corrections thing because maybe that's putting too much of a burden on us, then we really need to take that on board and investigate that and consider it before we suggest these discursive remedies. Gavin, you want to say something?
I mean, just on this, on single meaning, I mean, I get the concern from the media. I mean, two things. So one, as I understand it, determining the meaning can often be one of the most costly parts that involves these preliminary hearings that we're wrangling over the possible meanings of words that go on and on and on, and is a huge multiplier of legal costs. So I think one reason for getting rid of it is that you always have to balance out what you might purely want in terms of law, but what impact it actually has in terms of costs and the chilling effect that has upon both sides. And the other thing is just, I mean, provided you take Section 1 seriously, which we're gonna come on to, but that it actually has to be a really damaging insinuation, then they wouldn't have to correct minor errors. So they'd only have to correct seriously defamatory things that they'd said that actually they realised weren't true, or at least that people were reading it. A large amount of people were reading it that way. Which, and perhaps the claimant, I don't know how this could work, but, nowadays on Twitter, it's very easy to see how people are reading stuff. So, a claimant could easily, if they had to, produce evidence that there was a body of readers who were reading this defamatory insinuation in whatever the allegation was. If that was necessary, that would be quite easy to do, just a quick scour of Twitter. So I think that provided that, and I think Section 1 has been one of the most important reforms, actually, and I think it's turned out to again, perhaps have had more effect than we thought it might. And, it has raised the bar, and I think that's good, because I think it should be only quite serious things that, get anywhere near court. But if that's read, then with the discursive remedies of correcting things swiftly, then the media should be less worried, because while they may make a number of minor errors in many stories, hopefully they don't make a number of minor errors that are seriously defamatory in many stories that they publish. Or if they do, then they should correct them.
But then doesn't that require some determination and investigation into what actually qualifies as serious at some degree, and that it imposes an obligation on them to investigate what would be serious? Or are you suggesting that what's serious should be immediately obvious?
Well, I think I mean, it can be obvious in terms of the nature of the allegation. I think the courts have moved under Section 1 to suggesting you need to start to show some form of damage. I mean, not damage in the sense you'd have to show finally, but some indication that people are believing this and that it's changing their mind about you, as opposed to just showing the type of insinuation that it is. But I must admit, I haven't read that case law in detail. I don't know if the rest of you want to comment on that, how Section 1's been interpreted. I know we're sort of half moving towards it, but...
Well, yeah, let's talk about Section 1. I mean, certainly that is something that we haven't covered so far, and that was a contentious issue, as I understand it, for Scotland. It's been a contentious issue in the courts, and it was only really resolved, and perhaps some would say unsatisfactorily, with the Lachaud judgment in the Supreme Court in 2019. I mean, in your report, Andrew, in 2016, it was kind of like Section 1, yes, but some reservations about that. How do you feel about it now, then?
Well, I think my reservations now would be much, much stronger, I have to say. I mean, look, what the serious harm test was introduced to try and do was to work as a sort of early disruptor to, obviously trivial cases and also like transparently abusive cases. So very quickly, and the expectation was that these hearings would take place on a preliminary basis, and stupid or wrongful cases would be quickly dispensed with. There was always a question about whether that was necessary, because the common law, in part as influenced by Article 8, had already introduced sort of thresholds of seriousness into this area, which effectively served that purpose. But what then happened was that in the sort of early stages of the Lachaud litigation in the High Court, Section 1 was interpreted as requiring the provision of evidence as to the degree of harm that had been suffered. Okay, and that changed the ball game, because all of a sudden, the capacity for a claimant to bring a case was going to have to jump a really quite significant additional hurdle. Now, whenever I actually wrote this report in 2016, we had the Court of Appeal ruling, which reverted from that interpretation and said that evidence wouldn't be necessary, that seriousness could be inferred, and it's effectively just a reprising of the common law rule. Now, in addition, in the early stages of litigation in this area, there was a case called Cook against the Mirror Group newspapers, in which the court held that where a publisher had recognised the mistake and quickly corrected it, maybe apologised for it, offered a retraction, that would speak to the degree of seriousness. And so, to my mind, Section 1, if it did nothing else above and beyond the common law, at least encouraged fair play, if you want, and the type of responsibility post-publication that we've been talking about. What happened thereafter, however, is that the Court of Appeal ruling in the show was overturned by the Supreme Court. So all of a sudden, we're back in the ballpark of having to provide really quite substantial evidence as to whether or not harm has been caused. And with that, we saw a shift in the location of that determination from the preliminary hearing to the substantive hearing. Right. So no longer is Section 1 providing this gateway test. It's now a substantive element of the determination of the liable case at the end point of proceedings. And really what it's become has been no more, no less than a shifting of the burden of proof with regard to evidence, or with regard to harm, And so that's really the purpose that it's serving at the present time. And I'm just not sure, the deep irony as well is that at the preliminary stage, courts in England have begun to rejuvenate the old common law tests to serve the same sort of purpose in getting rid of the stupid and transparently abusive cases. So, Section 1 has become something entirely other than what it was intended to be, And in that context, then, the barrier that it introduces for claimants above and beyond what the common law previously did, I think is somewhat unconscionable, because the nature of harm in this area is very often entirely amorphous, So.
Can I just ask, I mean, it seems to me there's a kind of ambiguity in what, I'd forgotten it was Le Chaux, in what the Supreme Court held in Le Chaux, because it's not to be regarded as, Section 1 is not to be regarded as satisfied unless the allegation has caused or is likely to cause harm which is serious. So you don't have to show actual harm. You have to show either actual harm that's serious or the likelihood of harm that's serious. I'm just not sure what likelihood of harm that's serious what kind of evidence is now being required or offered.
But I think it's more factual rather. Before it was more a tendency that it would cause harm, and they would draw some inferences there. And now they're requiring some kind of facts, which is what you're talking about, Andrew. It's led to this complexity of the proceedings and things. But there is one. I mean, what you said is, it's reverted back to the kind of Thornton days of substantive hearings and a lot of complexity around there. But there is one substantial difference there, which you touched upon. And that's that it shifted the burden of proof. And it shifted the burden of proof in making it harder for claimants to bring claims in this area. And that was the purpose of the 2013 Act. It was set to address the chilling effect of free speech. And again, this comes back to this idea that it's hard to get this thing right. It's hard for it to be perfect. But is this where it necessarily just has to fall, in terms of the burden of proof has to fall more on claimants in order to achieve this objective of addressing the chilling effect on free speech that defamation law was having?
Well, I suppose if that is, I mean, look, the location of the burden of proof is an open question, and there is a reservation about the nature of harm, but then the courts can address that in some measure by inferring harm in serious cases, and so there are ways of managing the potential problem. But I almost sort of revert back to the type of complaint that Gavin has about Section 4. If the aim is to shift the burden of proof, then don't go into this language of serious harm and the meaning of defamatory. Just say the burden of proof with regard to proof of harm lies upon the plaintiff.
Yeah, it shouldn't have to go to the Supreme Court to decide whether or not Section 1 was designed to reverse the common law presumption. That shouldn't have to be litigated all the way up to the Supreme Court. If you can make that clear in the words, then do so. I mean, I assume now, if Northern Ireland enacted this, they would do so in the knowledge that this is what it would mean, because, the Supreme Court having ruled on it, then we know that that's what it would mean.
Well, again, the interesting thing is Scotland has considered all of these, and as I read it, they're considering it post Le Chaux Supreme Court judgment, and they still think it's worthy, and they have their adoption of Section 1 reflects the 2013 Act. They see it as necessary. There's been plenty of objections raised, plenty of calls for replacing the word serious with actual there. That has been rejected by Scottish ministers as not doing enough really to protect free speech. So it seems that, again, it's the imperfection of the language, but it's seen as being necessary in order to achieve those objectives.
But this is one situation where Northern Ireland will have to do something, because, as it has been argued, aspects of the new Section 1, and indeed even the discussion in the show, the common law of England and Wales may have got there post Thornton and various other cases, at least by a slower process, and maybe there's an acceleration there. The difficulty for Northern Ireland is there's even very limited authority as to the relevance of Thornton itself in Northern Ireland. It's really only a handful of cases, and all of the discussion that will now happen on the basis of Section 1 in the show and so on, without something in Northern Ireland, may have very limited impact on the way in which defamation disputes are dealt with. So although, again, there can be arguments for and against an exact textual parallel, there is this kind of breach in the common law in a matter that was almost entirely dealt with by the common law up to the 2013 Act. And that's different to other areas of defamation reform, because much of the 2013 Act, was playing around with areas that had already had statutory reform, whereas much of the debate around harm and thresholds was a strong common law area. And, Northern Ireland was already seeing sort of a slow process of adoption of that material, and now it's been further. So again, one can see why that's compelling in a Scottish context, particularly given the relevance of what's come from the Supreme Court. The other thing, however, to bear in mind is even if Section 1 has a major impact in weeding out claims, it still doesn't touch the other areas that a motivated claimant would want to deal with. And the Northern Irish courts have already seen, as in other parts of the United Kingdom, the triple or quadruple claim in order to get stuff taken down from social media. So you start with, this is defamatory, and it's misuse of private information, and it might be a breach of copyright, and it's probably a couple of GDPR violations thrown in. Now, the defamation one tends to fall first. And I think that's the experience in England and Wales as well, because of the way in which Section 1 may address the threshold, and because of other areas, the defamation one tends to get dumped, and sometimes even conceded by the claimant that this is going to be the hardest case to make. But the GDPR point survives, and often, is where it's going to be. So if the goal of Section 1 is to do something even better than Jamil, etc., and have a proper filter for seriousness, it may achieve that in defamation, but it's not going to achieve it in the other areas where showing particular models of serious harm, let alone damage, is not really part of the picture. I mean, the goals of some of the other causes of action are not dependent upon a Section 1 mentality, and certainly, of course, don't have that textual dimension. So its effects might also be limited in that regard. And the lived experience of the Northern Irish media practitioners is they tend to start off with at least 3, if not more, causes of action for most claims nowadays. And the fact that they might be, have a fair guess as to where the defamation one goes doesn't tell you all that much about what's going to happen with the other causes of action.
Okay, I'm just looking at the time here, and I'm getting a message. We need to think about 10 minutes for upload of the data. Data's getting us every time. But I just wanted to quickly address one last thing, and that's the suggestion about jury trials and abolition of jury trials. Andrew, you and I had talked about this before. Jury trials are seen as being important in Northern Ireland in a cultural, historical context. Diplock courts now, everything like that. Considering everything we've said about reducing complexity, reducing costs, is it not really valid for us to consider doing away with jury trials? Did they really add anything, legitimacy to it, in fact, anyway?
Well, I mean, yeah, so the default position in England is that under Section 11, trials will be held without juries. There's still provision for a jury to be reintroduced, but the way in which the jurisprudence is developed, it's quite difficult to understand the circumstances in which that would actually happen. So whenever we were sort of transposing that thinking to the Northern Irish context, my sort of starting point was to think that this would be an entirely unproblematic transposition. Because the existence of the jury and the requirement that the jury takes makes the factual determinations, that actually drives a lot of complexity in the legal argument, and hence increases costs. And if cost was the major problem, then removing the jury would be unproblematic. In the consultation with the Law Commission, though, we heard an awful lot of input from Northern Irish practitioners and others who were suggesting that actually, no, the jury has performed historically and probably continues to perform a really important role in this respect in the particular context of Northern Ireland. And I heard that from senior judges, senior lawyers. I confess that with an entirely pragmatic head on, I wasn't altogether persuaded. But I confess also that I probably just didn't understand the point fully, and it may be that there's peculiarity to the Northern Irish experience which warrants the keeping of a jury.
Okay. Well, I'm conscious now that we're right up on the time, and I'd like to thank you all for joining us. I think it's been a very helpful discussion, and thanks to the audience for listening. Thank you.